Thank you so much. Not to waste much time, so we hereby introduce John Montana, who is a fellow of the Institute of Information Management, our own institute, and also board member of the International University of Information Management. He has been in the business for over 20 years. So over to you, John Montana. Thank you so much.
Thank you very much. It's good to be here today. I apologize for our technical difficulties. That's part of the game, I guess, when you are speaking transcontinentally from around the world. But as always, it's a delight to be here with all of you and to speak with you about information management. This is a topic that is increasingly important in our world, and the work that all of us and all of you do is increasingly important, no matter where you are in the world, and no matter what your particular role may be. So this continues to be an area of growth, and I'm excited to be a part of it. I'm excited to be a part of the Institute. So I'm going to share my screen now, and someone needs to give me permission to share my screen. And let's try again. Nope. So whoever is the host needs to give me permission to share my screen, and we will commence. While we're waiting for that, I will tell you that I'm a co-host, so I guess I can do that. Let's see.
John and I co-host. Probably your voice is not too clear, please, John.
There we go. Okay. Okay, so here we are, and we will now commence the formal part of the presentation. So we're here to talk again this month in the second part of our series about data and information protection codes. And as part of our work, we all, I think, and this is true no matter what your role may be. You may be a member of a government agency that's charged with enforcing information laws and privacy laws. You may be an executive or an employee of an institution of some kind that handles personal financial information, such as a bank or other financial institution, or an insurance company, or perhaps just an employer who handles employee information. Or you may be a private citizen who has no professional connection to it, but nonetheless, all of these other parties, banks and government agencies and lots of other people are handling your personal information. So even if you have no direct professional connection, and I think most of us here do, but even if you do not, you have an interest in privacy laws, a great interest in privacy laws. And likewise, because codes of practice are such an important adjunct to them, you have an interest in codes of practice. So this is important to virtually everyone in virtually every country, because this is one of the truly hot topics. And even if your country does not have a privacy law at this time, it is likely to do so in the very near future. So let's talk a little bit about the ground rules of the session. We will attempt to leave time for questions and answers at the end of the session. We always have a chat function that you can put your questions into, and we'll try to get to them as we go. If you have a question later, by all means, feel free to email me at this address, jcmontana@yahoo.com, or you can find me on LinkedIn, and I am always happy to talk with professional colleagues. So do not hesitate for a moment to reach out to me through any of these vehicles should you have a question, a comment, or you just would like to talk. I'm always glad to talk with you. About me, a little bit was mentioned about me. I am the CEO of the Montana Group. I've been in this business for a very long time, since the early 90s. So that's getting to be quite a while now. I am in the United States of America. I am a practicing attorney in this country, and I have been about 32 years in this business. So I've seen a lot of the changes, which has been great because it's helpful to have that long view. But it's always interesting to see younger people with new ideas come up. I've been for most of that time in the governance privacy space, and here again is my email address should you wish to reach out to me. So a quick review of what we learned last month. First of all, we learned that codes of practice and extend and complain complex but high level laws. And we talked about how that's a common problem and quite a common and significant problem in the privacy area, because privacy laws often talk in very high level concepts and demand very high level outcomes, but give you very little practical guidance in how to achieve the outcomes that they demand of you, which is a critical shortcoming in those laws, because they oftentimes require very complex process changes to achieve, and oftentimes are accompanied by very high penalties. So the stakes are very high, but oftentimes the guidance that is necessary is missing. And then we're going to talk about how to get to that guidance now. It's important to remember that codes of practice may or may not have the force of law. Some of them are either adopted as laws themselves or incorporated by reference into other laws. Some of them are not. But in every case, a code of practice that is in wide use in any jurisdiction is evidence of reasonable practice and good practice. And that is always very, very important, because even if it doesn't have the force of law, if it's evidence of good practice, then conversely, not complying with whatever code of practice may be applicable to you is evidence of bad practice. And so you want to be aware of that fact. The key parts of the code of practice themselves are that a code of practice contains detail not found in the principal legal requirement. The whole point of the code of practice is to supply the detail that's missing. And likewise, with respect to industry-specific requirements, a privacy law, for example, may be very general and not have requirements applicable to a specific industry. Translating those high-level requirements into meaningful action items in your industry is very, very important, so that you can achieve some sort of compliance. And it is a key function of any code of practice, is to turn this high-level law into meaningful substantive action items that you can then act upon to develop a good privacy program in your organization. So the first question we should ask is, why should a government or agency care about a code of practice? And I think that's a pretty good starting place, because you might, for example, take the attitude, well, we're the government and we can make laws and people are required to comply with our laws. And because of that fact, we really don't need to obtain cooperation from anyone. We don't need anyone to provide detail that we sign on to, because we can write the law the way that we see fit. We're writing it the way that we believe is most effective, and we don't need anyone. You can say that, and once in a while you see a government that does say that. That's a poor attitude, though, and it's not in the government's own best interest. Primarily from a compliance standpoint. When we contemplate the issue of compliance, it's one thing, as we all know, no matter what country you live in, you see a lot of this, where the government passes a law and obtaining compliance from people, particularly voluntary compliance, is very difficult if people do not like the law. And people have 10,000 ways to get around any law. So any government, regardless of the form of government, regardless of the country, regardless of anything else, has a very, very strong interest in seeing its own laws complied with. And a code of practice, as we'll see for a variety of reasons, helps foster that compliance. So it's in any government's own best interest to seek full compliance with its own laws. A code of practice is a tool that can assist that. Cooperation is a big part of that. Compliance with laws, and we'll talk about this a little bit more in the next slide, is far more fully and effectively achieved when it's achieved through cooperative efforts with regulated parties. That is just the nature of the human condition. To the extent that you can turn anything into a cooperative effort, you are likely to get much higher levels of compliance from the other players. A code of practice properly developed is an exercise in cooperation and mutual benefit. So the cooperation aspect of developing a code of compliance is a very key aspect of achieving a high level of compliance with your law. Effectiveness, as we will see as we talk further, any law developed in a vacuum is going to be suboptimal, because however competent your government and its agencies and the employees of those agencies are, they do not necessarily have the hands-on expertise in, say, the financial services area that someone who runs a bank does. or the information management professionals, particularly in that bank. So to the extent that you can harness that subject matter expertise and build it into your legal regime, and a code of practice is a vehicle for doing that, then your law becomes more practical, more effective, and again, that fosters compliance. Public perception, a regulatory regime, and again, we will talk about this a little bit in the next slide, but a regulatory regime is far more likely to be accepted by the public and by the industries that it affects when it appears to have been drawn up in consultation with experts, regulated parties, and the public at large. And this is often a very key point. And oftentimes you see in this country, for example, regulations promulgated by federal agencies are subject to quite an extensive public review process where virtually anyone in the country, quite literally, can speak their mind on it, and the agency who's promulgating the regulation is required to respond to all of these comments. And the reason for that is the public perception aspect of this. Not only are they looking for substantive public input, but they want to make sure that everyone feels like they have been heard and that their views have been taken into account in the course of developing this law. And finally, education. Any law, particularly a technically complex law like privacy laws tend to be, is going to get a great deal more acceptance and thereby compliance if people are aware with some detail of what's required of them and what they need to do to comply. A code of practice that's been well developed and properly publicized is a highly effective education tool because it tells people exactly what is being demanded of them. So all of these things, the bottom line of them is that a government agency or any government entity has a strong incentive to develop a code of practice in consultation with the industry leaders and other players, because it will significantly foster compliance, and compliance is always good for any government. And even governments who do not mean any of these things will often put at least window dressing on these things and seek public comment just to attempt to achieve these things, because again, every government has a strong interest in compliance with its laws. I want to talk next a little bit about the psychology of legal compliance, because it's very important, and it's really a key factor in any code of practice for anything. The fact of the matter is that people don't like it when laws that affect them are passed without their consultation. Doesn't matter whether it's a good law. It doesn't matter whether it's a bad law. They just do not like the fact that they were not consulted. And this is a fundamental part of the human psychology, it seems like, because you see this in every country, in every situation, that people expect to be consulted if the government is going to tell them what to do. Conversely, a law that has received appropriate public consultation, and that includes not only the general public, but the industries that it affects and the people in those industries that it affects, such a law is likely to gain far more acceptance as people think that their opinions have been heard and their situation has been considered. And this is true even if their views don't make it into the final product. The mere fact that you have taken the trouble to listen and to respond often puts them at ease enough to gain you significant acceptance. And I will tell you that, well, I'll tell you in a second, because I want to get to these last 2 points. Typically, input from affected parties can also be incorporated to improve the law. Because no matter how good you are, no matter how much you think you may know about a subject, it's almost certain you don't know everything. And if you receive input from lots of other people, the subject matter experts out in the field, and that can include everybody from the information management professionals at a bank to the tellers who have to do the day-to-day work, all of these people know things about the process that you don't know. And all of them, their input can improve your final work product. So almost always you will see that if you receive broad input from a broad spectrum of people, that you can use that input to significantly improve your law. And by the way, in addition, the fact that when people see that their input has been reflected in the law, when they see that you have made changes based upon what they have said to you, they are likely to be far more satisfied with the law, far more content with complying with the law, and as a result, far more you will obtain a higher level of compliance. I can tell you from a long consulting practice that this is true in most environments. When we do a consulting project for a major company, for example, we typically solicit input in the form of comment, and we'll talk about how that process works. We solicit input from a wide variety of people at the organization that we're working with respect to the contents of policies and procedures and things like that. And we make a point of keeping a written tracking log of all of those comments, and we respond in writing to every single comment, so that to the extent we incorporate a comment into the final work product, we tell them that we're going to do so, and we tell them why. To the extent that we reject a comment, we give them an explanation as to why we reject it. I can tell you from 30 years of doing this that the comments materially improve the final work in every case. And number two, people are very satisfied with the result. Even when you have to explain to them that you're not going to do what they suggest, they are far more satisfied with the end product just because they feel like they've been listened to. That's very, very important. So who are the players in developing a code of practice? That's a very important question. First of all, the government itself, ideally, sometimes not, because the government is not interested in developing a code of practice. Oftentimes industry organizations and other such interested parties develop it independently. But if you get the government, it's important to bear in mind who the government is. It's a mix of politicians at the top. There's almost always a significant number of lawyers involved, because any law necessarily involves a number of bureaucratic lawyers in developing the law itself, career bureaucrats, and technical subject matter experts. The mix here is important because if you think about this, if you know anything about government agencies, these groups of people typically have different viewpoints, significantly different viewpoints, and likewise they may have different agendas and different outcomes. The politicians want one thing, the career bureaucrats and the technical subject matter experts want something else. And oftentimes there is a lot of discussion and dispute as to which viewpoint should prevail, or some hybrid viewpoint should prevail, because they have different, they're answering to different people, and they see the world in fundamentally different ways. It's also worth noting that the technical subject matter experts in an agency are likely to be different than the technical subject matter experts in, say, an industry group. For example, you take, because we're going to use financial services as our example industry today, in a government agency, you're going to have a lot of technical subject matter experts on finance and the technical aspects of finance, for example, but you may not have any experts who actually know how to run a retail bank. You certainly won't have any experts who are familiar with the workflow in teller operations or something like that, which oftentimes, and that's an important thing to bear in mind, because particularly in the case of privacy, a lot of the actual implementation of privacy laws takes place at a fairly low level in the organization in terms of work processes and paperwork flow and that sort of thing. And the kind of subject matter experts you're going to get in a government agency may not be familiar with that aspect of a banking operation. And we'll talk about that a little bit later. But these subject matter experts will be different than the subject matter experts you find in, say, organizations or industry organizations who are likely to be familiar with the nuts and bolts of running an organization. So in addition to the government itself, you have the regulated parties themselves. And this will be organizations such as, for example, banks and other financial institutions. It will be individuals, because if I'm a customer of a bank, this may impose some burdens on me and it may give me some rights. So I'm a part of the regulatory mix, and I'm certainly a person that has a great deal of interest in the question of data privacy with respect to my financial records. So I care about this initiative quite a lot if I'm an informed citizen. Then, of course, there are industry organizations who are oftentimes one of the key players in such an initiative, because they have a strong interest. All of their members have a strong interest in developing some sort of workable standard to implement something like a privacy law. And so they're working together and pooling resources. Finally, other interested parties, of which there may be many. And I mentioned IT manufacturers and associations as an example. And here's how they can become affected in this. To the extent that there's a privacy law that affects someone like a bank or any employer, oftentimes the requirements of that law significantly impact things like IT infrastructure, as I think you all realize. The IT manufacturer may not be directly impacted by the law in the sense of being a regulated party, but the requirements of the law will certainly impact their product development and their service offerings, because they have to make sure that the products and services that they offer are compliant with whatever these requirements are, so that they can continue to sell them into this industry. So someone like a chip manufacturer or the host of a cloud platform has a strong interest in understanding privacy laws and having input into them, because they're going to be dramatically affected, even though they're not directly speaking a regulated party. What they do is they sell things to regulated parties, and they have to make sure that the things that they sell will be compliant, or they won't be selling them. Where does the process begin? Well, it begins usually with a law, but not always. Industry associations may implement a code of practice as a law substitute when there is no specific law in question, and you oftentimes see this. But frequently these days, particularly in the privacy area, it generally starts with a national privacy law of some kind that requires explication. And the reason for a code of practice, and we'll look at this in a little bit more detail later, is that one or more of the parties in question, be it the agency itself that's charged with implementing the privacy law and enforcing the privacy law, be it the industry association that's charged with complying with the law, they realize that the law requires some explication in order to be implementable. And then they begin the process of attempting to develop that explication, that detail that's missing from the law itself. Why does the government need these people? Again, the government in theory doesn't need anybody. It can do what it likes. As I said earlier, one of the key reasons that it needs other parties is expertise. It is not uncommon in the absence of this kind of consultation to see laws that fail because they're essentially unworkable. And typically the reason they're unworkable is because the people who drafted the law did not consult with the right sort of experts, and they have written requirements which either are meaningless, which is not uncommon, or cannot be implemented for one reason or another. And the reasons are many. They could simply be too costly. They could be technologically infeasible. And customers might resist them because they impose some burden on the customer that the customer simply will not tolerate. And this is often the case with laws that have been written in a vacuum by politicians and government bureaucrats. So one of the things you're looking for is to bring in expertise in the specific technical areas that are going to require implementation, such as, for example, IT experts in the operation of a retail bank. That's an obvious example. There are many, many others where, in order to, and if you think about this, you'll see why it's true. Implementing a privacy law in an IT system involves some very technical aspects of IT configuration and IT architecture that only someone who has a great deal of hands-on experience in that particular environment is going to have. So that is part of the reason that privacy laws tend to be high level, is that the government agencies realize they do not have that expertise. So they set forth a desired outcome, and then you have to work back from that outcome to determine what the technical requirements to achieve it are. The second reason beyond expertise is buy-in. One of the things you want, and a privacy law is certainly a good case of this, is for as many parties and as many regulated parties to buy into what you're trying to achieve. one of the things a code of practice achieves as a matter of necessity, as an inevitable outcome, is consensus, because the code of practice, when it is completed, represents a consensus amongst all of the parties who are participating in the process that this is the go forward approach, and this is what constitutes effective compliance, and this is the details of that compliance. So you get a high degree of buy-in because you've achieved that consensus. And finally, the optics of it, the appearance of it. It's always in a government's best interest if it appears that it's seeking input from people. Governments do not like to appear high-handed. That's a bad idea. And particularly in any democratically elected situation, being high-handed can be a very expensive proposition for the ruling party. So, so the appearance of seeking input and responding to the input is a very important consideration over and above the actual technical value of getting that input. Why did the other parties need the government? That's the sort of the flip side of this question. The first one here is a very big reason. I mentioned that laws developed without consultation from industry experts are oftentimes unworkable laws for all sorts of reasons. You don't want this, because regardless of if you are, let's suppose you're a bank and your country promulgates some sort of privacy law, regardless of whether it's unworkable or not, you can be fined and sanctioned for not complying with it, right? So it's in your best interest to have a law that you can actually comply with. So your participation in the development of a code of practice allows you to help develop the details of the legal regime that you're going to be complying with. This is a key reason why industry associations, for example, develop codes of practice, because they want to have some say-so in what they're going to be expected to do, and they want to make sure that the things that they're being expected to do are things that they actually can do, that are technically feasible, that are cost-effective, that are not going to anger their customers. And so it's very important for them to participate in this kind of a process, because it allows them to control the process to a greater extent than they may be able to when the national parliament is debating a measure. Second reason, and this is equally important, is cooperation with a regulatory agency develops a friendly relationship with the regulators. You work together, you come to a consensus, and that is always helpful. Anyone who works in a regulated industry will appreciate the fact that an adversarial relationship with the agencies that regulate you is not a good thing. Now, mind you don't want to be so cozy that there is anything improper going on, but certainly a friendly, cooperative attitude with the agencies that you have to work with is a good thing for any organization, and help, being involved in the development of such a code of practice fosters that relationship. And finally, one of the artifacts of developing a code of practice is that there's a feedback and revision mechanism. If you do it properly, a code of practice receives input from a lot of parties, the government, the industry, associations, the general populace, and all of this goes into a feedback and revision loop where you draft something, you receive the comment, you make changes and discuss the comment, and you send it back out for another revision. And you do this multiple times, quite typically, to achieve a final work product. The development of this mechanism is a very good thing, because this is an artifact which can survive the code of practice itself and can be used for more effective governance, because now you have a way for people to communicate with government and for government to respond with them or respond to them. So this is a very powerful thing that is larger than just the code of practice. So where do we begin developing the code of practice?
Sorry, John.
Yes.
1 second, John, please. The voice is not too clear. Most persons are having difficulty to hear.
Let's see.
The volume, yes.
You are coming in very loud and clear here. So
Yeah, but you're not loud. There's some wumbling on your sound.
Okay. Let's take a moment here and
It's better. It's better now. It's better now.
Better now? Okay, so,
Yes.
so let me see if I can get closer to the microphone and I will speak louder. And if just interrupt if it's not coming through loud and clear. Okay, so let's see if we can make it work. So let's think a little bit about the process of developing a code of practice. First of all, you have to begin with a consideration of the law itself, and in particular the outcomes it drives. And privacy laws are an excellent example of outcome-driven legislation, because what privacy laws quite typically do is they state desired outcomes, and they demand that we achieve that particular outcome. But they almost always do not give you much detail, if any detail, about how you're actually supposed to achieve those outcomes. That's a big problem. If you take some of the major privacy laws that have been in effect for a few years now, for example, the GDPR in Europe, it's a good example of that. It states a great many high-level outcomes, but is virtually silent as to how you're supposed to achieve those outcomes, both with respect to business process and technical implementation issues. Those are left totally to you. And in the absence of a code of practice or some sort of subsidiary regulation, you are given no guidance whatsoever as to what constitutes appropriate practice. You are given no guidance whatsoever as to what technical changes you might need to make, and so on. So you are left to figure those things out for yourself, which has proven to be quite a challenge in the EU, and has resulted in the development of some codes of practice. But it remains a significant challenge because the law itself is so high-level vague. And so a code of practice is intended to respond to that by working back from those outcomes. First of all, you have to look at the outcomes themselves, and are they meaningful? They may not. The outcomes described may be meaningful, or they may be unmeaningful statements of principle. And if you look at the data privacy principles of the GDPR, they're a good example of that. They're not even outcomes. They are statements of principle that you have to derive outcomes from. So you have to, the first thing is to make sure that you understand those outcomes, and to the extent they're not meaningful outcomes and clear outcomes, you have to assign some sort of definition to them as part of the code of practice, because it's necessary to work back from that to achieve the rest of the code of practice. Once you've developed or identified the correct outcomes that you must achieve, you must then consider what processes have to be in place in order to drive those outcomes. And then working back from that, what technical infrastructure or architecture and business processes and workflows must be in place to drive those outcomes. And that is a key to this. You must work backward from the outcomes and develop from them, working backwards to the beginning to where you are, the necessary technical implementation processes that will force those outcomes. The result of this is a kind of gap analysis, because the law states high-end goals and outcomes, and typically that's all it states. To foster those outcomes, certain things must occur in your business, certain changes must be made in your business, and the gap analysis that will form the basis for a code of practice identifies the specific things that must occur that are not spelled out in sufficient detail in the law itself. That could include business practices, that could include business infrastructure, that could include technical configuration, that could include employee and user education and training. And the goal of the code of practice is to fill all those gaps so that you have a comprehensive map of what you need to do in order to achieve the outcome. Where do subject matter experts such as this audience fit into that? They provide a lot of the technical knowledge that's key to making a workable code of practice. Because if you're a subject matter expert and you're involved in one of these things, You should understand the business processes of your industry. You should understand, for example, the workflow of a bank. You should understand how the IT infrastructure of a bank works. You should understand customer needs and demands. Those are the kinds of things that get baked into a code of practice. You will also find, if you do this sort of thing, and I do this a lot, that you are a translator between two different sets of parties, because on one hand, you will have, for example, IT personnel, and on the other side of the table, you will have lawyers and politicians and folks of that sort. They have different agendas. They have different vocabularies. They see the outcomes differently, and they have very different conceptions of processes and outcomes. And so you have to serve quite often as if you have the skills to do so, and I hope you do, and if you don't, you should get them, but you oftentimes serve as a translator between these varying sets of parties who are speaking different languages, but who are working on a common goal. You have to be the person that translates between their languages and their conceptions of the world. What's the role of industry in all of this? The industry, whether it's an industry association or individual institutions within the industry, serve as a reality check. As we said earlier, the goal of a code of practice is to have an implementable, workable, and cost-effective regulation. Government agencies in the abstract often are not able to achieve these because they do not understand, for example, as much as they might, the costs of some of these things. And they may not understand from a technical aspect whether something is workable and implementable or not. Industry and its subject matter experts are the source of a reality check to make sure that these things are in place. Likewise, expertise, subject matter experts will commonly come from industry members. So the role of industry is as an incubator and source for these subject matter experts. As a coordinator, and one of the things an industry association can do that's very, very important is it brings a lot of players to the table. That's important for a couple of reasons. One, the more players are at the table, the more buy-in you get and the higher your level of compliance is. But also from the development of an effective code of practice, the more input you get from the more players, the more you can bake that input into your final work product and achieve a more successful, more workable code of practice. As a resource base, developing a code of practice requires infrastructure and human power and staffing and all kinds of other resources. Industries and industry associations and their members often provide a substantial amount of that resource base because they have the infrastructure in place to provide it, and it's in their own best interest to make that infrastructure available for something like this. And finally, as a publicity agent, an industry association, particularly when it achieves a good code of practice, has a high incentive to publicize that code of practice because it tells the public that we're doing good things in our industry about your data. So the industry and the industry association can often serve as an effective publicity agent, which again is good for the optics of everybody involved. And it's also good from the standpoint of building compliance as well. The role of the public, we haven't forgotten about them. To the extent that the average citizen on the street can be involved in this process from a comment standpoint, again, you achieve more buy-in because you've allowed people to speak and say their mind. But also, they bring a different perspective to this, and as a result of that perspective, they will offer suggestions, at least some of which will probably be very good suggestions that you should implement. So you will improve your work product as well as a result of gaining some input from the public. So what about building a process? How do we do that? And we're a little bit behind time, but I think we're about through here. One of the things, I've been involved in a lot of industry associations that have promulgated various kind of professional standards and this sort of thing. So I've done a lot of this sort of thing. I can tell you that you need to start small. You cannot, just as a practical matter, involve hundreds and hundreds of people in your inner deliberations, or you'll never get anything done. What you typically want is a small executive working group to coordinate the process, and then small subject matter groups working on specific aspects of the initiative. And if you think of a privacy law and its implementation in the financial services sector, you can see how these second might work, because you're going to have lots of different aspects of implementing a privacy law in the financial services area. You're going to have significant IT issues that have to be worked upon, and there may be more than one, requiring more than one work group. You will have business process issues and workflow issues and similar issues that require subject matter experts in those particular areas. And once you've got, we talked about developing the gap analysis and working back from the gap analysis. Once you've got that gap analysis, you can identify the correct working groups you need to tackle particular parts of this problem. Their work feeds back up to your executive working group, and who begins working on the ultimate document that you're going to develop. How do everybody else get involved? The typical way, and probably the best way, is that you make your working materials and your deliberations and your commentary widely available on a website or through some other such mechanism, and you actively solicit comments from people who are not involved in the working groups. And this is where you develop a feedback loop. You receive comments from whoever wants to comment and suggestions from them, and you work them through your feedback loop. You respond to this input, and you do so publicly. I certainly wouldn't advise doing anything privately in a situation like this. And you, as appropriate, you incorporate suggestions into your work product in order to improve it. And such a feedback loop is iterative, so that you will typically go through this multiple times over quite an extended period of time, sometimes a couple of years. And ultimately, you develop a provisional final work product that is a result of an iterative feedback loop, where you start here, you work through here, that work goes through this set of parties, and then their input goes back here, and you repeat this as long as you need to until you're satisfied that the result is a workable result and you gain the appropriate level of consensus that it's a good result. So let's look at an example of how this works very briefly. So here's something, and this is a piece of regulatory text that you might actually see in a privacy law someplace. Privacy laws tend to be written just exactly like this. A financial services business shall take reasonable steps to ensure that its customer records, this should be customer records, are securely stored and that access to them is controlled. That is a noble sentiment. I think we can all agree with it. But if you think about it, it's useless. If you are running a retail bank, this tells you nothing about what you actually need to know in order to comply with the privacy law in question. So it's a highly desirable outcome or statement of principle, but there's no meaningful direction at all. What does reasonable steps mean? What's an appropriate level of security? What's a reasonable level of access control? None of those things are discussed, so we have no standard against which to measure ourselves. And because of that, 1,000 other questions flow. And these are just a few of the many questions that one statement gives rise to. You know, are our current policies and procedures adequate? Who knows? What should we change? Who knows? How do we know when we've got it right if we do make changes? Well, you don't know. Again, everything is left uncertain and you have to guess. How might you deal with this? Well, here's a way you could deal with this. Let's take the question of system security. The code, and you can almost see in front of you the language of your code of practice. You could adopt an IT security standard, such as, for example, NIST 853 as part of your code. And that would be a clause in your code that the financial institution must comply with the provisions of NIST 853. Likewise, you could require two-factor identification. Likewise, you could require strong passwords as compared with weak passwords. For physical security, you could require the financial institution to have policies in the following areas. You could have a policy requiring locked filing areas and locked file cabinets. You could have a clean desk policy. And for those of you who may not know what that is, that's a policy that requires people to leave their desks empty and lock up all of the files and so forth in the said filing equipment, as compared with leaving work or leaving for lunch with your desk piled high with files containing personal information. A clean desk policy is kind of a standard tool that you use for that. Access limitation. The bank could require a need-to-know policy. The bank could require appropriate permissioning with the IT system, so that an employee doesn't have access to everything. An employee has access only to those parts of the IT system that are necessary for their job, which is, again, another common practice. Okay, and you could have specific instructions for personnel with respect to the handling of personal information. So, for example, you could put in a work instruction or procedure that says to use shredders for documents containing personal information, not to put them in the wastebasket. Again, a standard process. And you can see all of these occupying probably a page in a code of practice that responds directly to the previous slide and provides people with specific guidance on how they're going to achieve that very high level outcome that was set forth in the previous slide. And of course, these are only examples. There are others, and you could certainly do them differently. And these might be supplemented by other kinds of tools. So for example, the implementation of NIST 853 is a complex process and would take a lot of doing. And you might have all sorts of other tools, in order to achieve that. We talked a little bit last time about tools to supplement the code of practice. You would probably see a lot of that in the system security area, because you would need those other tools, because this is, again, fairly high level. It gives you a lot of detail as to where you need to go to look for some things, but this would require some work to achieve. So the bottom line is, this is the kind of detail that the code of practice would contain. And this is the kind of detail you would need, because this this is action items. This you can go out and work on. You can start to achieve compliance with NIST 800. You can implement two-factor authentication. You can require strong passwords. You can do all of these other things. You can write policies that require them, and you can enforce those policies. That gives you specific action items to work upon. And as importantly, because this code of practice has been adopted by not only industry, but by the regulatory agency that governs industry, you know that if you do these things, you're in compliance with the law, so that you don't have to worry about being called to the carpet and sanctioned in some way with a fine or some other penalty because you weren't complying with the law. If you're doing these things, you're complying with the law. So it gives you concrete action items, but it also gives you an assurance that what you're doing is actually legally compliant, which that language that I showed you does not do for you. So what do we remember about this? What do we have to remember about this? First of all, it's an iterative process. Code of practice will typically take a number of iterations and input from a number of parties to achieve. Bear in mind that more input from more interested parties is desirable. You have to control that input through some sort of notice and comment process in order to not be overwhelmed and make sure that you have a rational process that doesn't get out of control. But that input is going to be desirable, and it will materially improve both the quality of your work product and the effectiveness in achieving compliance with your code and with the law that is driving your code. Remember that all input is valuable, even if you disagree with it. There's a human tendency to ascribe little value to things that we disagree with in situations like this. But remember, if some important player disagrees with what you're saying, it's worth thinking about and at least responding to them, even if you ultimately do not implement whatever it is that they're wanting you to do. Expect significant changes. The way your code of practice starts out is probably not going to be what it looks like when you are finally done with it. It's going to change significantly. And remember that even after it's promulgated, as with any set of requirements, we think we've got a really great work product that will accomplish our goals. What we inevitably discover after a year or 2 or 3 or 5 in the real world is some of our assumptions were wrong because the world might have changed, or maybe our assumption was wrong in the first place, or there's a better way to do it because technology has changed, or just because we didn't think of that better way. So don't assume that your final work product is the final work product, because it never is. This, as with any such thing, is a living document that will change over time, and it should change over time. And that's why you need that feedback loop that you have built to receive input so that you can make those changes. And with that, I think we are to questions, if we have any.
Thank you very much, John. I guess another good set piece out there. Thank you so much.
My pleasure.
I think we have a question. And the question is regarding what's the relevant. Okay, I think before we go to the question, we have a poll question for the users, right? And after that, we'll take the other questions. John, can you see the poll question?
I can indeed, yes.
Yes. So will we allow the participants some 5 minutes to answer this? Then we will go through it. Then we answer other questions. Please, I will advise all the participants to please look at this and then give us the answers to the processes here, to the questions, I mean, sorry. So this is in line with what John has been talking about from last month to this month. Okay. So we just had 2% yet. So 3% is okay. We have 49 active participants. I can see the pool, but 3% has completed the pool. 4% has completed the pool. Please, we are encouraged to attend to the pool just to. So we have 4%, and we just have 8%. So I think everyone is on it. We have 5 now. Okay, 8% now. So John, you are going to once we are done, you are going to look at the answer. Then we will discuss that. Then we answer the question. I think there's only one question on the chat box, right?
Okay.
Hope that works, right? So we have 20%. Okay. Because at the end of the webinar, we'll be giving out attendance continuous professional development certificates for those that attended and did well in the pool. Just to test the knowledge of persons on understanding of what John has been teaching since the past 1 month. Okay, I think we are making progress. So we have 21% out of 48. Person disconnecting from it. Please, I will encourage everyone to participate. So that's to prove the understanding of the the webinar. Please note that we will not display your names towards the answers, right? So rest assured, we're not going to do that. We've got 24 persons out of 49. We have 50K exemption of myself, the president, and John. So we should have 49, that's correct. So we have 25% out of 49. We've got 26 persons, 27. So now, John, we've got 59% so far of the persons that have responded to the questions. So we've got 36 persons that have answered. We have 73% so far that had attended to the pool. I think that's enough. So I think I should end the pool. I should give it one more. We have 36 persons. Oh, it's 50 now. 72%. Okay, thank you so much. I will have to end the pool. John, can you see the pool?
I can indeed, yes.
Okay, I want to end the pool now. And then the result will be shown, then we move on to the explanations using that. For those that got, okay. So John, the first one, yes, everyone says, yeah, they're right there. What is not a code of practice, right? So, so John, over to you.
Okay, so what is not a code of practice? As we discussed, a statute and regulation is typically not a code of practice. A statute or a regulation may incorporate a code of practice into it, but the code of practice is itself subsidiary to the statute or regulation, functioning as an explanation of it, if you like. Likewise, it's not a principle, because principles are always quite high level. And again, the purpose of a code of practice is to provide the detail that the principle embodies or states. So the code of practice can be said to embody the principle, but it's really far more detailed than any principle. A code of practice is in fact guidance. So that's the one that should not be here. Code of practice is in fact guidance. It's intended to be guidance. Its role is as guidance. So the first two are correct answers. The second is not, or the third is not, pardon me, C. Next, what is a code of practice? A code of guidance, a set of minimum rules, standards, and good practices. Yes, those are all of the things that a code of practice is intended to be. And it's intended to provide you guidance on these very things. What are the minimum rules? What are the standards that we should comply with? What are good practices within our industry or our job function? What is a code of practice be? Regulations, laws, bills, and act. No, a code of practice is almost always not a law. It's, again, subsidiary to a law and explains the law, but and it may even be incorporated into a law and given the force of law, but it's not in and of itself a law. Number two
is A.
Yes.
2 is A. Yes, correct.
Yeah, 3 is A. None of the above. Oh, I missed it. Yes, didn't I? None of the above is not correct, because again, a code of practice is a set of minimum rules, standards, and good practices. So number 3 is not correct. Question 3: where do codes of practice originate? Industry organizations. Yes, quite commonly they arise from industry organizations. Standards organizations, once in a while they do. So you may see NIST or ANSI or some such organization develop a code of practice. It's not as common as industry organizations, but it does happen. Government regulators. Yes, although usually in coordination with industry organizations and other interested parties. They don't often do it in a vacuum, but government regulators are quite commonly involved in the developments of codes of practice. So, which leads us to D, all of the above. In fact, all of the above are correct. So D is really the best answer.
Yes, all of the above is the answer. D is the answer for number 3. So 77% got it right. That's correct. So number 4, please.
Number 4. In every case, a code of practice is intended to facilitate A, legal compliance. Yes, absolutely. A key goal of any code of practice is to ensure compliance with the law that the code of practice addresses. Good practices. Yes, absolutely. Good practices by definition, foster legal compliance. So A and B go hand in hand. The code of practice is absolutely intended to develop good practices in the organization. Legal measures. This is C, ambiguous.
Yes.
I take it to mean that the legislation itself, and the answer would be no in that case. And because A and B are yeses, D, none of the above is not a correct answer. So A and B are both correct ansers.
But the most correct is going to be the good practices because
Yes,
it helps to
I
establish good
would say
practices
so, yes.
to aid good legal compliance. Okay.
Yes.
Right, number 4 is B. All right, number 5.
Number 5.
We have, yeah.
Go ahead.
No, go ahead, sorry.
A code of practice can also be incorporated into laws in full or by reference, thereby giving them legal effect. That is true. And as we saw in Malaysia last year, is true.
Yes.
So A is the correct answer.
Yeah, that's correct. All right, number 6.
Number 6, why develop a code of practice? A, development of a consensus of accepted practice. Yes, absolutely. That is a reason to develop a code of practice. It's an opportunity to coordinate with regulators. B, yes, it is absolutely a reason to develop a code of practice because you want the consensus to include the regulators so that they buy into the consensus. It's C, an opportunity to clarify high level or vague requirements. Yes, that is likewise a reason to develop a code of practice. D, good public relations for your industry and your association. Absolutely, that is oftentimes a driver. And as a result, because all of these are true, E, all of the above is in fact the best answer.
Yes, number 6 is E, that's correct. Number 7, codes of practice are valuable adjuncts to law. That was topic for last month.
The answer A, true, is in fact correct. A code of practice is an extremely valuable adjunct to law, and oftentimes is critically necessary to achieve effective compliance within the industry. So the final one is true.
Okay, good. So for our attendees, most of you are requesting to share results. Yes, we've shared the result, and John has answered the questions. So that is, thank you so much for that. So John, we have the questions in the chat box, right? So I will need to, gosh, am I stuck? Did I minimize?
Yes, I'm happy to discuss these questions.
Yeah, so we have just 3 questions. So you have one from Dr. Raphael Akan. I think he had asked the first one. He said, what is the relevance of data to public debates and private decisions?
That's an interesting question. I take that to mean what is well, maybe I should ask a question myself.
Exactly.
And if the good doctor can explain his question a little bit further, that would be helpful. Put that in the chat box. Tell me a little bit more about your question. I'm not sure I understand it fully. While you're doing that, let's go on to the next question and wait for the doctor to explain that a little bit further.
Okay, so Dr. Raphael, I'll have to unmute you. Dr. Raphael, can you unmute yourself and just clarify your question? So, 1 second, let me try and unmute Dr. Raphael. Dr. Raphael, can you unmute yourself? Just let me know. Okay, ask to unmute. You can unmute yourself now, Dr. Raphael. Yeah.
Hello. Yeah. Can you hear me?
Yes.
Yeah, we can hear you. Thanks, please.
Yeah, thank you very much. I just simply want to know the relevance of the data and it's talking about how important, how useful data to public debate and private decision making. Since we know that data is not just only what affects a private person, but also the public as well. So I just want to know that the importance of this data to public discussion and also the private decision making. That is just what I meant by AIDS. So I just need some kind of clarification. So that's what I mean. Thank you.
The importance of that feedback loop cannot be overestimated. If you think of a privacy law in particular, and privacy is a really good example of this. A privacy law says very simple things, and the example that I gave in the presentation is good. Is a good example of that. But it's essentially meaningless. And in order to develop meaning, in order to put real meaning to that, that people will accept. You have to develop some sort of consensus about what is meant by things like reasonably protect or adequate protection, or all of those kinds of things that you see in privacy laws. So the more people and the more organizational parties that you obtain input from in developing that consensus about what that language means, the more effectively you can develop a meaningful, workable definition of it, and from that workable definition of it, effective processes and technologies to control it. So that data, that input data from all of these various parties, is a critical aspect of doing this, because if you don't have that data, you don't have that consensus. And if you don't have that consensus, you really can't write a code of practice. And if you try to write one, it won't be effective, because prior to achieving a code of practice, prior to writing a code of practice, it's necessary to achieve a consensus on what things mean and what are reasonable things to do. The only way to achieve that consensus is by talking to a lot of people.
Yeah, thank you, John. Dr. Raphael, I hope you got the answer to your question. I think during the presentation, you had mentioned most of that.
Yes, very well. Thank you very much.
Yeah, thank
We have another question here that I will just read. It says, what are the data security arrangements governing access? This is a good example of why a code of practice is necessary. It's critically necessary, because if you look at the language that I posed as a sample, as an example, it doesn't tell you anything about what are appropriate data security arrangements. In the abstract, we don't know what are appropriate data security arrangements, because we don't know what is technologically feasible. We do not know what is fiscally feasible. We don't know how the information is being used, and we don't know the workflow necessary to run the business. We don't know all kinds of things that we need to know. And because of that, we can't possibly know what's an appropriate security arrangement. The goal of the code of practice is to provide us with those intermediary decisions, so that, because in order to state a data security arrangement of some kind, whether it's a technological configuration or a business process control in the form of a policy, we have to know one, what we really mean by data security. What does that mean in the real world in terms of practical things to do? And then we need to know what's actually achievable in the practical world. And from that, we can derive a workable data security arrangement that will function in our industry, both as a security arrangement and still permit us to perform our business functions. One of the problems with trying to do this without this process is that you come up with unworkable standards that no one can comply with for one reason or another, either because they won't let the business run or they just are technologically unworkable. So the answer is the data security arrangements for access and other things depend on the consensus we've achieved. They are the product of a consensus, and until you know what that consensus is, you don't know what the data security arrangements, because that consensus will drive those data security arrangements in a lot of ways. Likewise, we have another question. Can you explain?
John, 1 second.
Yeah.
John, we have Olufemi Daniel. This is our regulator. His hand is being raised up, so just give him a. Let's hear him out, please. Okay, Femi, over to you, please. You can unmute.
Thank you very much, Mr. Alexander. Can you hear me, please?
Yes.
Can you hear
yes,
me?
we can hear you. Yes, we can.
All right.
John, can you hear me?
Yes.
Yes. Thank you, John. Thank you so much for coming around again, and it had been a very interesting session. I wanted to just attempt Dr. Akongbe's question on, in government setting, what are necessary steps to be taken to establish lasting code of conduct in data or information protection? If you don't mind, can I attempt to answer that question?
Sure.
Okay. Yes, sure, go ahead.
So I think for well, the code of conduct are as useful to government as much as it's useful to the private sector. But my thinking is that there may just be, different emphasis in the implementation journey. Unlike in private sector, for you to establish a sustainable code of practice, it must be based on a regulation or a law. While in the private sector, there could be an industry, aggregation of industry experience, but there should be for public sector, particularly from our own experience in Africa and Nigeria, and I think it applies to substantially a lot of public sectors across the world, is there must be a law that is the fountainhead for that particular action or code of practice you want to do. And the next thing is for you to invest properly in training and awareness, because people in government take longer time to be able to assimilate, not for deficiency of competence, but because there are so many things that government officials are doing, there is a possibility of distraction. So training and awareness needs to be focused and needs to be consistent over time. And then after that, we need to now encourage those government and officials to do standards, to get into standards and certifications, to get certified and have and learn standards that could be relevant to their. And the final step is that they should not be core part of those who are developing that code of practice. By doing this organically, it makes the implementation to be much more it percolates into the system, and I think it would work better for the public sector if this approach is taken. These are just my thoughts. Thank you very much.
I think those are great comments, and they point to something which is worth bearing in mind, which is that in a governmental agency has a completely different set of players and a completely different set of drivers than does private industry. And a code of practice, if it's going to be generally applicable, has to accommodate the tension between these two sets of parties. If it's strictly a code of practice for government operations, it has to be developed in a way that accommodates the unique situation that a government agency is in, which is a very different situation than private industry. So I think that's an excellent discussion of of that situation, and certainly worth thinking about for the rest of us.
Yeah, thank you so much, Femi, for that. And that was a brilliant contribution. And yes, like John Montana have said, there are various code of practices for each sector, be it public sector, private sector, and within private sector, you have other sub sectors that you can have. So thank you so much. So without any further questions, I can see. Okay, this is just a comment from Dr. William Odenwike. He's just talking about, I see a code of conduct as a paperwork in Nigeria because it is not practiced. And Dr. Williams, for the public sector, it's going to work. Like you said, is a gradual process here. Start it small, take it big. So for the private sector, it works most times. It does work, but for public sector, I think NIDA is doing a great job. I can tell you for free. NIDA is taking it gradually. Years back, for decades, nothing has been happening that the way what is happening in NIDA right now. So I think for their public sector, we should be able to give it to NIDA for the work. And for what we're doing now, I think we have to be able to collaborate with NIDA to put up some good practice for each sector. That's why we're having this webinar. But so far, there's a lot that NIDA is doing. So we talked about, Dr. Williams is talking about the code of practice on paper that is not practiced. I can tell you it's not for NISTA, right? He talked about new passport rules, right? If that is regulated by NIDA, I can promise you're going to see actions. Just to answer that question there. Okay, so having said that, there are no further questions that I can see here. So I just want to appreciate, I appreciate John Montana for this great session. Thank you as always, John. And we want to acknowledge our Executive Council members that are here in the house. If you please kindly introduce yourself. I can see Mrs. Faraday. I can start from Dr. our ambassador. Please, over to you. Please introduce yourself for those people that don't know you. Ambassador, please. As the president, then.
Thank you, Mr. Nago. Good evening once again, distinguished ladies and gentlemen. I'm Ambassador Dr. Ayodeji Wole-Edokun, President, Chair in Council of the Institute of Information Management. Nice to be here this evening.
Thank you so much, Mr. President. And over to Mrs. Faraday, please. If you are there, please, kindly. Mrs. Faraday, I can see you there, please. Can you introduce yourself? Executive Council member. Mrs. Faraday, are you there? I can see you. Oh,
okay.
Maybe she's having issues with that. Okay, so my humble self, I'm the Executive Council member in charge of public relations and sponsorship. I'm the coordinator for this event. However, I would like to acknowledge all the professional fellows in the house, our dear fellows in information management in the Institute, and also acknowledge the various Director Generals in the house, Director of the Mr. Dr. Vincent, or Mr. Dr. Vincent Latuji, who is in the house from NISTA, the Director in charge of our regulations in NDPR, is one of us, the fellow. Thank you so much for coming. We also have the DG for the Bureau of Public Mr. Dasuki Ibrahim Arabi, okay, who is present in the house today. He's also a professional fellow of our Grace Institute that we acknowledge you.
Bureau of Public Service Reform.
Yes. I think my mic went mute there. That's Bureau of Public Service Reform. I will urge Mr. President to give us a vote of thanks and also acknowledge the various dignitaries in the House. Thank you. Over to you, Mr. President.
Thank you very much, Mr. Nago. Once again, on behalf of the IIM Africa Executive Council, I want to thank you all for making our time, even for, despite the fact that we started late, from the list, we can still see that a very good number of attendees are still up and online. So we want to thank you, and we hope you will avail us your time again next month, when we'll be coming up with another interesting topic for discussion. And as usual, in our pool of international professionals across the globe, we shall be having another wonderful session that is going to enrich us in terms of knowledge, exposures in the management of data and information, so that in our organizations, we can have proper data governance and also ensure that data is adequately protected within the organization. So thank you very much. Wishing you all a wonderful afternoon for those that are in other climes, and those of us in Nigeria, do have a wonderful night and warm regards to the family. Thank you. So
Thank you for that. Yes, sir.
Yeah, the date for the next webinar will be communicated. We have your details. The secretariat will do that shortly, and the team for the month of August will equally be disclosed. So over to you, Mr. Nago.
Okay, thank you, Mr. President, and we appreciate everyone for attending, and especially for everyone that attended the pool. I've just put a message on the chat box for you to have the slides for today's webinar. You have to be a member that is in good standing, and send your request to training@im-africa.org. You will get the training slides and the recording for those that is in a good standing. So thank you so much. And I think we might have to have a group photograph online. So please just exercise some patience for us to have that. Mr. President, so can we take
Can we turn on our camera for those that would like their faces to show? Let's turn on our cameras and position ourselves for the group photo. Okay. It's going to be taking, we actually have two screens. So the first screen, we're going to take that after countdown of 5. We're starting from 5, 4, 3, 2, 1. It's taking. The next slide, please. Just a minute. The next slide. Five, 4, 3, 2, 1. Thank you all, and have a wonderful night rest.
Thank you very much, Mr. President, and every other person.
Thank you very much, Mr. President. Have a lovely night rest.
Thank you, everyone. Have a good night rest.